Today's webinar is about Medicaid and common estate planning mistakes. Let me take a moment to introduce our speaker, Jason Neufeld. Jason is the managing partner of Elder Needs Law. Elder Needs Law primarily focuses on Medicaid planning, estate planning, and probate administration. Jason is an AV preeminent rated attorney by Martindale-Hubbell and is consistently recognized as a top lawyer among his peers in Super Lawyers Magazine and Florida Trends Legal Elite. Jason is on the board of the Academy of Florida Elder Law Attorneys and co-chair of the Broward County Bar Association Elder Law Section. Jason both teaches other elder law attorneys about Medicaid planning, as well as regularly presents in front of community organizations. I will now turn the time over to Jason.
Good afternoon. Can you hear me all right? My sound's coming in? Terrific. Thank you. Okay, everyone. Thank you very much for joining. Let me take a moment to share my screen because I have a little presentation. It's for you guys. Okay. All right. So you should see a PowerPoint and there we go. Okay. So good afternoon again. I am Jason Neufeld, and I'm going to afterwards put my email in the chat. And if you are interested, only if you're interested, I do have some free giveaways for you. I can email you directly. We have a little estate planning booklet and a Medicaid planning booklet if you'd like. Each is between maybe 10 to 12 pages, something like that. If you're interested in a free healthcare surrogate designation form, I'm also happy to send that your way. We have what we call our lifestyle aspirations worksheet, which I will explain what that means later on. And certainly if you are in Florida or anywhere in Florida or thinking about moving to Florida and are interested in working with us, we also include $100 off anything that we do. Again, there is no obligation. If you just want the good education, I'm happy to be here and deliver that as well. So, okay. I'll tell you just one quick minute about myself. I am born and raised in the city of North Miami Beach. I only left briefly to go to Emory University in Atlanta, and I came right back down to South Florida to attend University of Miami, where I got my joint JD MBA. In law school, I met my wife, Marla. That's Marla sitting next to me on the couch, and we have our two boys, Ethan and Asher. Ethan's next to Marla, Asher's next to me, and of course, in the middle is always the star of the show. That's our COVID dog, Zeke. I am active in the community. I am on, as Kat said, I am on the Executive Council and Board of Directors for the Academy of Florida Elder Law Attorneys. I am on the co-chair of the Broward County Bar Association's Elder Law section. I teach other people how to do this stuff, not dabbling. So I'd like to start with something very, very basic, which is when I tell people I'm an elder law attorney, sometimes I'm met with a blank stare, and the question is, well, what the heck does that mean? And it's a very fair question because elder law refers to multiple different things. There are some areas of law that you are undoubtedly familiar with. There's like estate planning, which is your wills and your trusts and your powers of attorney and your healthcare surrogates, right? Who can make decisions for you if you're unable to make decisions for yourself? Who gets your stuff after you pass away? How do we make that happen in the most efficient way possible? So that's estate planning in a nutshell. If you haven't done a good enough job with estate planning, sometimes you have to go through this court process known as probate. We help people with that as well. There's what's called a guardianship. If you haven't planned properly and we need someone else we need a judge to decide who can make decisions for you, that's called a guardianship. And then there are some areas of elder law that are a little less known, such as special needs planning and Medicaid planning. In my firm, we're 3 attorneys. I am the one who focuses on the Medicaid planning and the special needs planning. And my teammates focus on the estate planning and probate side of things. And we'll talk a little bit about estate planning today as well. So the focus really is what's Medicaid planning. I've given this presentation to the Leukemia and Lymphoma Society, so I know it's a similar set of interested individuals as this organization. And the idea is that medical care can be very expensive, even with Medicare. And beyond that, if we're getting to the point where we need help remaining independent, we need help at home, or we need help paying for an assisted living facility or a nursing home, the idea is who's going to pay for that stuff? Because Medicare, which is what we all get when we turn 65, or if you're younger than 65, 2 years after becoming disabled, officially disabled by Social Security. But a lot of people are shocked to realize that Medicare does not have a very good long-term care benefit, whether it's providing care at home or in a facility. That's where Medicaid can come in. Medicaid is one of the answers, not the only answer, one of the answers to the question, how are we going to afford to pay for these things? Right? Because there are other options, including privately paying, right? For my clients who have millions of dollars in the bank or otherwise independently wealthy, that's wonderful, right? Cash is always going to be king. Cash is always going to be the easiest way to get anything that you need to get done in the healthcare space. For those who cannot afford to privately pay or are going to go near close to broke before if they use all their money to privately pay. Medicare does have a limited benefit. It is not really great for home care. You have to have doctor prescribed skilled care like physical therapy, nursing therapy, occupational therapy, speech therapy in order to get anything to do with unskilled care, which is helping to pay for your activities of daily living. So Medicare, again, very, very limited, and it can go away. Medicare won't pay 1 red cent toward the cost of an assisted living facility. And in a nursing facility, Medicare will only cover up to 100 days. And not all of those 100 days are going to be in full. It depends on your Medicare supplement. The first 20 days will be paid in full. The remaining 80 out of 100 days may or may not have a copay, depending on your Medicare supplement. For veterans or the widows of veterans, there is a VA aid and attendance benefit. That is a potential source of additional funds as well. For long-term care insurance is a wonderful tool, but the problem is once you need it, it's too late to get it, right? You have to get long-term care insurance when you're younger and healthier in order to be underwritable. Otherwise, it just really typically becomes cost prohibitive to get long-term care insurance, which is why fewer than 10% of Americans have it. And then there is Medicaid, which is, of course, the focus of my conversation today. Medicaid is more than one thing, I like to point out. When someone tells me that they're on Medicaid or they're interested in Medicaid, my next question is, well, which Medicaid? Medicaid, they're in Florida, which is where I practice. It's the only state in which I practice. Medicaid, there's probably 14 or 15 different flavors of Medicaid, of which I only work with about three of them, about three of the Medicaid programs. But Medicaid in general is a state and federal partnership where the federal government provides about 51 cents to the dollar, the states provide the remaining. And what happens is the federal government can set basic criteria, and then the state can operate within that criteria, right? That's why the laws are different. So for example, if you're interested in Medicaid in a state other than Florida, I would have to refer you to a Medicaid planning attorney in that state, because the way we protect income and assets in Florida is and the standards, what you need in order to qualify, is going to be different, or can be different, among 50 states. So this is a Florida specific presentation. In Florida, you have to have less than $2,000 in what Medicaid considers to be accountable assets combined, and you have to have less than $2,829 of monthly income coming in from all sources combined, including Social Security and pensions and retirement funds and all that good stuff. And so sometimes when I mention that in these presentations, people start, they start clicking off, or they start checking their phones because they go, oh, this doesn't apply to me, because they're saying to themselves, well, I am no Rockefeller. I've got more than $2,000 in the bank, Jason. So why are you wasting our time? I'm too rich to qualify for Medicaid. But that is precisely the individual that I'm here to help, right? The idea is that if you're already indigent, you may naturally qualify for these programs. If you are independently wealthy, then you just privately pay for it. It's everyone in the middle that is getting the short end of the stick, and that's who I'm able to help. That's who I'm serving. All right, so here are the three primary Medicaid programs that I spend most of my time working with. The first one is called the Institutional Care Program. That is only for people who need skilled nursing facility or nursing home, a nursing home level of care. So that's rehab facilities, skilled nursing facilities, nursing homes. Okay. Then the next level down, where actually most of my clients want to be, is they want help receiving care either in an assisted living facility, which sounds like a nursing facility, but they're different, or they want to receive care at home. Okay. Those are my clients who are going to be interested in a different Medicaid program referred to as Medicaid waiver, or the home and community-based services Medicaid program. And then we have QMB. These are for actually a lot more relevant to my blood cancer or other non-long-term care related patients, because clients, because these are the individuals who don't necessarily need long-term care, but they have very, very expensive medications and treatments that they're taking. And sometimes their Medicare plan or health insurance plan is insufficient to cover all those costs. And they have substantial out-of-pocket expenses, and Medicaid can help with that as well. And for those who aren't on Medicare, there's another Medicaid program that I don't have listed here, referred to as Meds AD, which is Medicaid for the aged or disabled. So they have very similar health insurance and prescription drug and treatment related benefits, not on a long-term care basis, only for those who don't have Medicare. If you have Medicare, but you don't need long-term care, we're going to put you in the QMB model. If you don't need long-term care but have significant health insurance related expenses, we're going to be looking at the Meds AD model of care. But we're focused on, really, most of my firm is focused on people who not only need help paying for significant health costs, but want to stay at home or need help paying for the cost for a facility. So they're in the Medicaid waiver or the ICP program. For those individuals, there is that $28.29 per month income test in Florida. That amount increases every January. So this is not a fixed amount. It goes up every year. And they are looking at everything that you have combined: Social Security, pension, rental income, IRA distributions, however money's coming in a given month. To the extent that it exceeds $28.29, we are going to need to place the difference in what's referred to as a Miller Trust, also known as a qualified income trust. Okay. Now, you don't lose access to this income, meaning you place as an example, as a silly example, if your income was $2,929 per month, we would have an income trust that you would transfer $100 into every single month that you wanted to be eligible for Medicaid. You don't lose that $100. You put the money in, and the money can come right back out to pay for anything you need or want, essentially, that's related to your care. While there is a Medicaid payback obligation on any funds remaining in this trust after my Medicaid client passes away, we don't care about that so much, because this is not the type of trust where money accumulates. Money goes in, money comes right back out. If there happens to be a couple $100 or even a couple $1,000 in there after my client passes away, they will lose it to the government, but they will have received many, many, many multiples of value in return for that. And if you are able to spend it all and there's nothing left in that trust when you pass away, or when my client passes away, there's nothing to pay back to the government. So that part is really not that big of a deal. The asset test is really why most people are coming to me. It's because they are only allowed to have $2,000 in what Medicaid considers to be countable assets, and they don't want to have to spend all that before naturally becoming eligible. So fortunately, in Florida, we have some wiggle room, because not all assets are countable against that $2,000 limit. An example is your home. Your primary residence, generally speaking, is not going to be counted as an asset. So they're not going to force you to sell your home. Now, there is a $713,000 equity limit. What I mean by that is, if the home is worth $800,000 and you have a $100,000 mortgage, that's $700,000 in equity, and you're good to go. If you have significantly more equity than that, we have other ways of dealing with that issue, but I don't encounter that so often. And if you're married, interestingly enough, or you have dependent children living in that home, there are no equity limits. Your home can be worth millions of dollars, and Medicaid can't say anything about it. You are allowed to have one car of any value. And then there are some other items that I've listed here that I'm not going to read out to you that you're allowed to have, and Medicaid will essentially not be interested in those assets when determining whether you are or are not eligible for Medicaid. But nearly everything is countable, right? I mean, money in the bank, money in a standard brokerage, non-IRA brokerage account, vacation homes that aren't being rented out or that you're not living in. Those are potential issues for which we have to develop a plan if you want to be eligible for any of these Medicaid programs. I will mention there is what we call the CSRA, Community Spouse Resource Allowance. That is a concept that's only applicable if I have my Medicaid client who is married to a healthier spouse who does him or herself not need Medicaid. And for that healthier spouse who doesn't need Medicaid, we refer to them as the community spouse. And the community spouse is entitled to have up to $154,000 in change in their name alone, while my client can only have $2,000 in his or her name alone, and we can be eligible. So if a married couple comes to me and they have $156,000 in countable assets, we're just going to move some money around, and we don't have to deploy any of these other strategies that I'm going to go through with you in a moment, because they're sort of naturally eligible. And the good news is spouses can gift between each other. Spouses can gift between each other without penalty. The problem is Medicaid applicants cannot give to anyone outside of the marital unit. You can't give things to children or friends and say, hold on to this for me because I have too much that's preventing me from being eligible for Medicaid. That's where people get into trouble. So when people come to me, they have significant assets, and we're able to legally and ethically get assets out of their name in a Medicaid compliant manner. Okay, in a way that's not going to trigger that 5-year gifting look back penalty. That's essentially what we're doing. And how do we do that? Well, we're going to talk about some different strategies involved, but essentially it's getting the money out of their names. Sometimes it's spending money, sometimes it's utilizing some of my neat Medicaid planning strategies for asset protection purposes. But the idea is that we're recognizing that we need this money. My client needs this money because Medicaid pays for a lot, but it doesn't pay for everything. So it's nice to have money set aside in a way where it can supplement the quality of their life. And then, of course, the secondary purpose is to make it a little more likely that they'll have something to pass on to whoever it is they want to inherit their assets after they pass away. So otherwise, my clients are not my clients, but other people who are waiting to naturally qualify for Medicaid. They're spending everything. And it's unfortunate because they don't have to do that to be eligible for Medicaid. And a prime example of this is this is my client, Janice. Now, Janice is a real person. That's not a real picture of Janice. That's just a stock photo. But Janice is a real person. And as a side note, I want to mention that while my firm is called Elder Needs Law, that is the name of my law firm, and I'm considered an elder law attorney, I do not only work with senior citizens. I work with lots and lots of people who are under the age of 65, not senior citizens, but are disabled, and they need help paying for this stuff as well. But certainly the majority of people I work with are elderly, because that just, as we get older, becomes more likely we'll need long-term care. But if you need long-term care and you're under the age of 65 and over the age of 18, we can, and anywhere in the state of Florida, we can assist with that as well. So Janice was the sad story where, a lot of people don't realize that what we do even exists. Even I can be in a room of lawyers and half of them won't know that what I do exists. And Janice was a prime example of that, where her sister had called me and indicated that, well, we sold our house. We're down to our last $7,000. Now we're really freaking out because we don't know how we're going to pay for this assisted living facility. And I waited 5 years because I know that's how long you need to wait for. And, now can you help us? And I kind of, it was very sad, very sad phone call, because I had to indicate to Janice's sister, you didn't have to wait 5 years. You didn't have to sell the house. You didn't have to wait till you were down to your last few dollars to call me. We could have gotten your sister taken care of a long, long time ago without having her to spend everything down. And that's the problem, is a lot of people are confused about this look back period. And it causes a lot of confusion, it causes a lot of distress, and it causes a lot of people to become unnecessarily impoverished. Okay. So if you leave this presentation with one concept, understanding one concept, it's that I want you to tell everybody you do not have to wait 5 years to qualify for Medicaid. You can. There's sometimes when you for people who don't need care in the next 5 years, there's a different set of strategies to deal with that. But for people, most 99% of my clients need Medicaid yesterday. If they all had to wait 5 years, I wouldn't be, I'd have to be doing something else because that's a very, very small percentage of the people that I help. So this is the misconception. Medicaid does have the right to look back 5 years in, I think, 48 out of 50 states. I could be wrong. Again, I'm focused on Florida. If you're in another state, we got to get you to, I got colleagues all over the country. I got to get you to somebody in the state in which you're concerned about. But for my colleagues for my clients in Florida, there is a 5 year look back period. Medicaid is allowed to go back 5 years and look at all funds, how they left your account. And if it is true that you, in fact, gifted money away, if you said, I've got $200,000 and I'm going to give all but 2,000 of it to my kids within 5 years, that's a big problem. That's a big problem. And that is where the 5 year look back period gets people in trouble. Or this other example I gave is, they say, listen, the IRS says I can gift $18,000 a year, so that's okay, right? And I say, no, you can't do that either. That's the IRS. We're talking about Medicaid. Those are two separate government agencies. They don't always play nicely with each other. They have separate rules, okay? So what we're doing is getting money out of our clients' names within 5 years, typically within a few months of applying for Medicaid, but we don't hide anything. We explain to the government exactly. We're going to say, my client started off with $500,000. Now he has $2,000. Here's what we did with that money. And here's the corresponding state and federal law that says that's okay. And what we did is not subject to the 5 year look back period. Okay. So you don't, again, if you leave here with one concept, you don't have to wait 5 years to get help paying for significant medical expenses or long-term care expenses. And how do we do that? What is it that we're able to do within a matter of months in order to qualify for these valuable benefits? Well, there's a combination of different strategies. There's probably a dozen different strategies. These are some of the more popular ones that I work with. They all have pros and cons. They all have pros and cons. I do not have a magic special trust that has no drawbacks to it. Everything I do will have a drawback. So what we're typically doing is using a combination of different strategies to minimize the drawbacks. And it depends on my individual client, right? People have different life circumstances, and it's going to be, and what works for one isn't going to be the best plan for somebody else. But this is a list on your screen of different strategies that we can use, and I'll review them very, very quickly. Each of these are, the subject of its own CLE webinar because these are all complicated strategies. But essentially, we do have special needs trusts. That is, these trusts do have a special designation under state and federal law, which is any amount of money placed into now we have to be careful here because you might have a revocable trust. You might have an irrevocable trust. You might have a living trust, which is the same thing as a revocable trust, but not everyone knows that. These are different. I mentioned a Miller trust a few slides ago for excess income. These are all different. I'm talking about a new type of trust. There's hundreds of different types of trusts out there. A special needs trust has to be properly drafted. And if it is properly drafted, funds placed in the trust are not counted as a gift, and money can be spent on anything my client needs or wants. There are some spending restrictions if they are on SSI, not Social Security retirement, not Social Security disability income, supplemental security income. You're on SSI if your income from the government is $943 or less. If it's more, you're not on SSI, you're on SSDI or Social Security retirement. So only if you're on SSI, there are some spending restrictions. But the big drawback with this trust is after my client passes away, the state of Florida will have their hand out saying, out of the money left in this trust, we want to get paid back first. And only if we can get paid back first And if there's money still left over, can the family get anything? Okay. So that's one strategy. Another strategy is personal services contracts. Now, this is another a prime example of why you need to be with a lawyer who knows Medicaid in the state in which you're looking for benefits. Personal services contracts, to my knowledge, are not available in any other state other than Florida. So we got to be careful. Make sure you're working with the right professional. But personal services contracts essentially allow us to pay in advance a family member or friend for the hours that they're spending doing stuff for you. So we often have a situation where I have my client who is looking for Medicaid is already working with their son or daughter because their son or daughter or a combination are paying bills and driving them to doctor's appointments and preparing meals and calling in to make sure that they're okay and dealing with their finances. They're managing their life, the life already, or they're starting to, right? So personal services contracts allows us to pay that child caregiver, even sometimes from a distance, in one lump sum. And sometimes, depending on the age of my client, it can be hundreds of thousands of dollars. So the benefit is money stays in the family. There's no Medicaid payback obligation, but there is an income tax consequence, right? Whoever's receiving the money, the adult child caregiver, right? Money's leaving mom or dad's name, typically going to adult caregiver child. The IRS doesn't care that that person happens to be related to the Medicaid recipient that they're caring about, right? They are a service provider. They have to pay income tax. If we're transferring $100,000 or $200,000, that's a significant tax bill. Okay. We also have annuities and promissory notes and interesting investments, and we have these other neat tools that we can use that, again, I think are beyond the scope of this presentation because they're just too in depth. But the last one I want to mention, because spending one's own money is absolutely valid. So we're sometimes looking at things like paying off a mortgage, which is my client. You can pay off my client's own debt or the debt of their spouse is perfectly valid. Prepaying for funeral or burial expenses, right? We don't like to think about this stuff, but someone's going to have to spend money on that at some point in time. And it's a wonderful service to be able to relieve your family of the need to plan a funeral and make those arrangements after you've passed away, because they are going to be grieving. And so if you can take one less thing for them to do off their plate, and while we're in the business of getting money out of my client's name to qualify them for Medicaid, we may as well take advantage of things that are practical to spend money on. But making improvements to the homestead, again, buying a new air conditioning unit, buying a hospital bed, buying a nicer wheelchair, right? Home safety improvements, whatever is going to improve the quality of my client's life is absolutely going to be a valid way to spend their money. They just can't give it away. Okay. And this is a very Larry and Angela happy story. Larry and Angela are not real clients. They're just prototypical clients where they have a home worth about $600,000, 300 to $500,000 in the bank, and we're able to use a combination of those strategies to legally and ethically get, I guess, Larry in this sample needs long-term care, so we can, they don't have to spend all that money. Because I would suggest to you that if I have a married couple and one of them is sick and the other is not, it is an incredible disservice to force both spouses into abject poverty so one can qualify for Medicaid. So again, the money is very meaningful for Angela in this example while getting Larry the help that he needs. Okay, you guys are going to be interested in this. So here's once we've done all of our machinations, once we've protected the income and protected the assets, and we've submitted an application and we've gotten our client eligible for these Medicaid benefits, what is it going to pay for? So we have some wonderful benefits. We have Medicare premiums and prescription costs. So my clients will have no more co-pays, no more deductibles. For prescriptions, they'll have between a $0 to $12 per prescription copay on any prescription that's Medicare approved. So if it's on a Medicare approved list, Medicaid will pay for it. So every once in a while, we get into some experimental prescriptions that Medicaid won't cover because it's not a Medicare approved prescription, but otherwise prescription costs are going away or nearly going away. For my clients who need home care, Medicaid is typically initially approving somewhere between 15 and 40 hours a week. They're supposed to approve everything my client needs, but every once in a while, we're in a position where we have to appeal, what they think you need and what you think you need don't always match. And sometimes we have to fight for more hours. But whatever they approve initially, it will be helpful. It just may not cover everything that you need. In an assisted living facility setting, I'm on number 4, you are restricted in terms of going to a facility that accepts Medicaid. In an ALF setting, there are many nice facilities that accept Medicaid. This is another common misconception. People say, I don't want to be relegated to a Medicaid facility because I've heard they're not as nice. And while there are some super luxury ALFs that won't take Medicaid, but there are a lot of very nice facilities that will. So what you have to be aware of is in an ALF, those in Florida, those typically cost, let's say, between $3,000 and $6,000, right? Can be less, can be more, but that's kind of a solid bell curve, I think. In an ALF, there's really 2 components of that bill. There's a rent component of the bill, and then there's what Medicaid, or what they refer to as the level of care component of the bill. Medicaid only pays the level of care component of the bill. They don't pay the rent. So sometimes my client's income, even plus what Medicaid covers, is not enough to cover the ALF bill. That's what makes Medicaid planning even more important in that setting, because if we can set some money aside to cover the rent portion that my client's income is insufficient to cover, all the better. If they needed to be in a nursing home, Medicaid pays for all of it, except for my client's income. So my client's income goes to the facility. They get to keep their monthly income. They get to keep $160, and Medicaid pays for everything else. These are the facilities that cost between $9,000 and $14,000 a month. So losing the income in favor of Medicaid paying the vast majority of the bill is usually a acceptable compromise. If my client is married, there are ways to divert a portion or sometimes all of the income to the well spouse. We can show that the well spouse is dependent on that income to live his or her life. Okay. And then number 6, you can see some other miscellaneous items as well. We've got I like to point out the chemotherapy drugs, the radiation treatments, diagnostic tests, some mental health services, some nutrition devices and feeding pumps, and there's more. Essentially, you can look at what a Medicaid managed care plan offers to get a full list of everything they cover, but there's some significant expenses that Medicaid will in fact cover. There is a concept known as Medicaid estate recovery, which is what is the setting in which Medicaid will ask for some money back. So we already talked about the special needs trust. That's one. That's why we depending on how much money we're talking about, but we will rarely take all of our clients' money and throw it into one of those special needs trusts because of this Medicaid estate recovery problem. Florida has a very Medicaid planning friendly state compared to other states, meaning other states are a lot more aggressive in terms of what they're going to try to chase after when a Medicaid recipient passes away. But that's an important part, which is Medicaid never makes any recovery attempt until after the Medicaid recipient has passed away. And in Florida, other than that special needs trust, they're only looking at assets that go through the probate process. That's where estate planning comes in, okay? Because if we can avoid probate, we can avoid having to pay mostly or nearly everything back to Medicaid. So this is where we do not want to be reliant on a will. So here's the part that dovetails very nicely into some estate planning mistakes that people make, which is this is for everybody, right? A will, a last will and testament, is a one-way ticket to probate court. If you're reliant on a will, you're going to court. That's because a will doesn't do anything for anyone, has no effect on anyone's life until it's presented to a judge, which means probate court. If you have assets that go through the probate court process, every judge in the state of Florida, if you're over the age of 55, I think every judge in the state of Florida is going to require you to put Medicaid on notice. Then Medicaid becomes a creditor, like any other creditor. You forget to pay your credit card bill, they become a creditor. You have other debts, they become a creditor. And Medicaid's a creditor like any other creditor, and creditors have the right to get paid out of a probatable estate first before beneficiaries. So Medicaid will have their hand out, as will Visa, as will the unpaid FPL bill, right? And they want to get paid back before family gets $1. So if we can avoid probate, we can avoid all that, okay? Some other estate planning mistakes that I see people make is they don't understand the importance of a Medicaid compliant durable power of attorney. So a power of attorney is the most important document that I can provide my clients, whether or not they need Medicaid at the time. Because remember, our firm does straight estate planning as well, not necessarily just for people who want long-term care benefits. So sometimes people come to me and they go, well, I downloaded this power of attorney off the internet. Why do I need to pay you for that? Or sometimes they go to other types of attorneys, like their divorce lawyer or their bankruptcy lawyer, who I think with good intentions, they're trying to be helpful. And they say, hey, while you're with me and while I'm helping you with your divorce or while I'm helping you with your bankruptcy or whatever, your personal injury case, whatever the case is, let's get you a good power of attorney and some basic estate planning documents. But these are not one size fits all documents. In Florida, since 2011, the law changed that says you have to be very specific in what you're what you're going to delegate to someone else to do for you. Meaning you cannot just say in a document, I give my agent the ability to do everything for me, so help me God, as if they were me, right? You can't do that anymore. You have to be very specific. And when we're talking about Medicaid planning, specificity is important because some of the stuff that we're doing is very complex and it doesn't involve just dealing with the bank. It doesn't involve just dealing with the real estate, which is what I see these form documents being fined for. So a lot of people come to me with powers of attorney that are good for certain things and not good for other things. They're incomplete. They're not strong enough. So I want my clients to have a well-drafted, what we call our Medicaid compliant durable power of attorney, because I want my clients to have the world of planning opportunities open to them should they need care in the future and should they be unable to sign for things themselves. Because if they don't have their mind, if they lose the ability to make decisions for themselves, we can't sign a new power of attorney at that point in time. They can't sign anything at that point in time. That's where we're going to a guardianship. That's where we have to go in front of a judge and say, Your Honor, we don't have a good enough power of attorney, or we don't have any power of attorney at all, and we need you, Your Honor, to designate the right person to be able to make these decisions. Unnecessary complicated, unnecessary expensive, unnecessarily time consuming. Okay, so we want to avoid that. All right. So to avoid probate, we're typically relying on one of two things. The first might be reliant on a pay on death designation, right? If you have a bank account and you list who can receive that bank account after you pass away, that can avoid probate. With real estate, we're sometimes talking about what we call a ladybird deed in Florida. Again, this is a deed that's not available everywhere, but in the state of Florida, we have what's called a ladybird deed, where essentially you're saying, my Medicaid applicant is essentially saying, I own this property and I continue to be the sole owner of this property, but the deed says, after I pass away, here's who becomes the new owners. And if it's in the deed, then it's good. But what's important is while you're alive, while the Medicaid recipient is alive, the other people listed on the deed have zero ownership interest. That's really important for a few reasons. The first is if you just add someone to the deed, which is a big mistake for multiple reasons. If you just add, a lot of people go, I want to avoid probate, I'm going to add my kids to the deed. It's a big problem. While it avoids probate, you've created another couple of other problems. The first problem is you've now gifted an asset away. part of an asset away, right? If you own part of a home and you add your children to the deed, you've now you've gifted them an interest in your home. And while it will avoid probate, it will penalize you if you need Medicaid within 5 years. So why do we need to do any of that if we can just use this ladybird deed or a revocable living trust, which says only after I pass away do these people become owners outside of the probate context. So there's that. Another reason why you don't want to add people to your deed right now is there is this concept known as a step up in basis. This means after you pass away, you're going to be giving your, I'm going to call it children, right? It doesn't have to be children, but let's say you add your children to the deed. You're giving them a unnecessary tax burden, because if they are gifted part of a home during your lifetime, when they go to sell it after you pass away, they will pay taxes on the difference between your purchase price and whatever they sell it for. So I see this, I saw this the other day, and I don't know where everyone here is from, but there's a town in a suburb of Miami called Miami Shores. There's very, very old homes in Miami Shores that in the 80s people bought for $30,000, $40,000, $50,000, and now they're worth $700,000, $800,000, more or less, right? So if they added their child to the deed, and then the child goes to sell it later, they'd pay taxes on, let's call it $50,000 purchase price, $800,000 sale price. They would pay taxes on $750,000 of capital gains. It's a big problem. But if they inherit the property after they pass away through a trust or a ladybird deed, they pay taxes on the difference between what the value of the property was at the date of my client's death and whatever they sell it for. So essentially, there's no taxes or very little taxes paid. So this is why good, solid estate planning is going to be very, very important as well. So if you leave with if you can avoid a few estate planning mistakes, number one, get a good, durable power of attorney. Hopefully it's a Medicaid compliant, durable power of attorney to be able to protect your assets down the line, even if you don't need Medicaid right now. Number two, don't be reliant on a will. A will means probate. Even if you don't need Medicaid ever, probate is unnecessarily expensive and time consuming, right? We offer probate for people who haven't planned properly, but I would rather people avoid probate with good planning. So will means probate, if that's what you're relying on. So let's not be a will's better to have a will than not have a will, but we don't want to just be reliant on that for our estate plan. And the third is, don't add your children to the deed. There are some rare circumstances where that will make sense, but we got to really want to think that through, because there's often a better way to accomplish whatever your goal is, other than doing that. Okay, so bring it back from estate planning. Now we're going back to Medicaid planning. If we can avoid probate, we can minimize or eliminate what might need to get paid back to the government to avoid that estate recovery. I want to just dive a little bit deeper into these non-Medicaid planning, non-long-term care Medicaid programs. And I touched on this a little bit earlier, but there is either QMB or the Meds AD programs. Now, there's a couple other programs listed here. There's SLMB and QI1, but if you come to me and you say, I'm interested in QI1, I'm going to tell you, I'm not going to help you get QI1. I'm not going to help you get SLMB, because we have the tools where I can just get you QMB, and QMB gets you all the benefits of SLMB and QI1 plus, right? So if I'm going to get you, even if you don't need long-term care, I'm going to get you on the highest level Medicaid program to cover your health insurance expenses and Medicare Part B premiums and your prescription coverage and copays and all that good stuff. And if you are a Medicare recipient and we get you on QMB, you get to then enroll in what's called a DSNP plan, or a dual enrolled special needs plan. That's for people who have Medicare and Medicaid, and that's where we're often able to get you some additional income in your pocket. We're able to get you, cell phones, and there are these little, not only will you not have to pay for health insurance or prescription coverage anymore, but there are these other little benefits that come with it as well. Okay, we're getting to the end. So I do have a book. If you are interested, it is available on Amazon. I think it's $10 if you have a Kindle and maybe $16 if you want the hard copy. I update it once a year. So this was updated in January of 2024. It's called How to Get Medicaid to Pay for Some or All of Your Long-Term Care Expenses without having to wait 5 years, without having to sell your house, without having to go broke first. It is Florida specific. It is Florida specific. There's some concepts that will apply in all 50 states, but again, I'm only licensed in Florida. I only work with clients in Florida, so I have made it a Florida-based book. Again, I want to remind you, if you want to email me, jason@elderneedslaw.com, and you want to ask me a question that you're not comfortable asking the group here, and you want any of these giveaways that I've offered to you, I'm happy to provide that to you. I'm committed to, I do charge for consultations, but I am committed to free and very low cost information. That's why I send out these practical booklets to anyone who wants. I have a very active YouTube channel where, again, I promise there's no sales involved other than, like, here's my name and phone number if you want to call me, but I'm answering people's very specific questions. I'm educating people about Medicaid and estate planning throughout Florida. And we have the book and the website. I write articles all the time. Again, the idea is not to say you need to call me to get the answers. It's to give away the answers. And of course, if you need someone in Florida to help you implement a plan, I hope you'll consider us. But if you work with somebody else, promise I'm okay with that too. And if it's good information that helps you avoid having to hire any lawyer in the first place, even better. So with that, it has been my pleasure to speak to you all. If you have any questions, I think I'm hanging out here for another 12 minutes. So happy to answer any questions you might have.
Thank you so much, Jason.
Yeah.
Let me get my slides up real quick. Okay, so it's now time for the discussion part of today's event. And if you would like to ask a question, or you can make a comment by typing it in the chat box, or you can raise your hand and speak. If raising your hand, once you are called upon, then you can unmute yourself. So while I'm waiting for any questions in the chat box, let's see, I had a couple of questions of my own.
Okay.
You mentioned like a 2-year wait between being disabled and receiving Medicaid. What are some options for people during that time, like if they can't afford anything?
So thank you for, pardon me, choking on water. Thank you for asking that, because Medicare and Medicaid sound too alike, and so people sometimes confuse those terms. So what I was mentioning was, if you have been deemed disabled by Social Security, meaning if you've worked at sufficient quarters and you're deemed disabled and you are approved for SSDI, there is then, with a few exceptions, which is ALS and end-stage renal disease, I think, except for those diagnoses, if you have been approved for SSDI, then from the date you were approved or should have been approved, there is a 2-year waiting period before you will then be eligible for Medicare for free. So Medicare, again, you've worked sufficient quarters, you've paid into the system, you get Medicare normally when you turn 65, but if you want Medicare before you turn 65, it's because you've been deemed disabled. So for Medicare, you wait 2 years. Now, that doesn't mean you have to wait 2 years to get access to health insurance or long-term care benefits, because that is where we help our clients get onto Medicaid. And Medicaid has no wait. There is some programs do have a wait list associated with it, but for example, the QMB program or the Meds AD program has no wait list. Meaning we can get people health insurance and prescription drug coverage and copay coverage within a few months. The waiver program, which is the one that helps pay for home care or ALF care, that does have a wait list. And part of our job is we're able to significantly reduce the amount of time people spend on that wait list, but they can be on another program that does not have a wait list while we're waiting for those higher level Medicaid benefits to to come about.
Okay, thank you. That makes a lot
Sure.
more. Another common question I saw when I was researching this was, when should estate planning begin? At what age or at what point is
I
it?
think so. There are some attorneys who will say if you're 18 years old and in college, you need at least incapacity planning, right? You need your power of attorney and a healthcare surrogate because once you are an adult, your parents or siblings or wherever you were used to helping you, access medical records and make decisions for you can no longer do so. And this has been a problem sometimes on college campuses where kids get into accidents and they're in the hospital and they're not conscious and they have to run and get a guardianship because healthcare decisions can't get made while you're not able to make decisions for yourself. I would tell you that that's what estate planning attorneys will say. I have yet to be approached by a college child or college aged adult who wants any kind of estate plan. My probably more realistic suggestion is if you have children, you need an estate plan. If you own real estate, I think you need a revocable trust based estate plan because these are significant assets. And if you have children, we want our documents are going to include who can make healthcare decisions for your minor child if you're unable to do so, if you're all in the same car accident together. And again, who's going to be their guardian? God forbid the worst happens. How are we going to protect what you've built up over your career? If you have life insurance, how are we going to protect all that so it's for the benefit of your children? So if you have minor children, or you own property, I truly believe it's time to get some kind of an estate plan. And then typically you are adjusting that plan once every, I'd say 7 to 10 years, unless something significant happens in the interim. So that's my rule of thumb, I think.
Okay, perfect. That's actually was a question I also had, is how often you need
Yeah.
to adjust it. For someone who needs to get all this paperwork done, how much is it something they have to pay for each time they adjust it? How much in general? I mean, I know you only work in
Yeah.
Florida. Would someone have to pay to have someone help them pre-plan all this?
Yeah, it really depends on what they need, but I'd say they should expect for if they want estate planning, just general run of the mill estate planning, I think they're going to be between $1,000 and $4,000. I think generally speaking, if you don't need a trust, you're going to be on the lower end of that spectrum. If you don't need any estate planning, you just need the incapacity planning documents. I think you're going to be then more between $500 and $1,000. So it really just depends on what the individual needs that will dictate what the costs are.
Okay, cool. That's more affordable than I thought it'd
Yeah.
be.
Yep. Yeah. I think it's a great point that you brought up because, especially when I say revocable trust, people think, you have to be only the wealthy get trusts, and that's really not true. Really, again, my rule of thumb is if you own real estate, or if you have special needs children, you need a trust. You need a trust.
Perfect. Thank
Yep.
you.
You're welcome.
Seen any questions in the box, so we'll just move on from there.
Mhm.
Before we go, I'd like to mention one of our very important programs called HealthTree Cure Hub. At HealthTree, we believe educated patients and researchers create better and faster cures. HealthTree Cure Hub to be active to actively participate in their health journey while providing researchers with valuable insights from real-world experiences like yours. We invite you to join the 12,000 and counting blood cancer patients who are currently impacting their outcomes while accelerating research by participating in Cure Hub. Cure Hub is a one-stop platform that provides the ability to connect to your surveys to studies submitted by DLBCL and follicular lymphoma experts, securely connect your medical records to track your disease, discover clinical trials personalized to you, anonymously connect to your genetic twin match, and lastly, gain access to a database of side effect solutions provided by other blood cancer patients. There's a link for DLBCL on here that you can go to sign up for this. And then there's a link on this slide for follicular lymphoma. And here are some upcoming events we have. Monday, June 24th, we have Nikki's story and why she's grateful for her follicular lymphoma diagnosis. And then on June 26th, we have a hospice event for DLBCL and follicular lymphoma. And then Thursday, June 26th, we also have a virtual HealthTree Cure Tour. As always, I'd like to thank our sponsors again that are Regeneron and BMS. And thank you, Jason, for being here today. And thank you for everyone who joined our webinar for being here. And my email is kat@healthtree.org if you would like to contact me.
Thank you for inviting me. Nice to see everybody.
Thank you so much. Have a great day, everybody.